Cook, Marquette, Ponder, and Wolves are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
And welcome back to the second half of Tell Me I Have a Case. Matt Glenn with Dan Grimm. We're from Cook, Marquette, Ponder, and Wolves. We can be found at cbpw-law.com and 573-335-6651. Now, the first half of the show, we talked a little bit about what to do after a car accident. What are some of the other types of injuries people have?
Sure. Some common injuries we see is what's called a premises case, or slip and fall, where somebody's at a location, typically at some type of store that sells goods, and we see slip and falls or even trip and falls. Just like in car accident cases, are there certain things you see as far as how people that are injured in a premises case, how they should react?
Yeah, for about 15 years, I defended these cases, and the majority of cases that I defended were premises liability cases, or basically somebody that fell. I've had clients come in, and really everyone has the same reason for the fall. It's gravity. I can assure you that the gravity out there is strong as ever. The real question is, what caused you to lose your balance and take a tumble? Most people will walk through a store and you'll ask them when they come out, so what did you look at while you were in there? And honestly, they can't really even tell you. And almost no one knows what causes them to slip and fall at the time they're slipping and falling. As they're going down, it's a shock to them. And what they don't realize is that they're about to be asked a lot of questions by an expert manager who's going to try to document things in such a way to show that they aren't liable. So there are a lot of things you gotta look at when you're talking to them.
So as far as what are some of the things that you've seen on when you represented insurance companies, as far as the information that they're trying to get out of the person that maybe slipped or fall or tripped or fell at a store?
Well, they're trying to paint you as somebody who wasn't looking where they were going. They're trying to paint you as somebody who isn't taking responsibility for keeping yourself from falling. Typically speaking, at a box store or at a grocery store, a slip and fall is usually on some form of liquid. Somebody has spilled something, you step on it, it's a tile floor or a concrete floor, and it's usually very slick, and you go down. The manager will come to you and say, well, where were you looking? Like, weren't you watching? Were you watching where you were going? And the person will say, well, gosh, I guess not. I'm a little embarrassed. The reality is, if you really think about it, when you're in one of those stores, your eyes are on the items on the shelf. And that's where that store wants your eyes to be. They want you looking at the merchandise because they want you to buy the merchandise. And so typically the merchandise is very pretty colors. It sometimes has a sign on it. We've all seen the yellow signs at the grocery store indicating something's on sale. That's where they want your eyes. The only thing in that store that is not for sale is the floor. Right? You're not going to be able to buy the floor, so they don't want you looking at the floor. So typically speaking, you go down, you were probably looking at some merchandise, determining whether or not you're going to buy it, or whether or not, like I was in the store yesterday, looking for the Carnation Instant Breakfast. Right? Looking everywhere for it. I don't think I ever once glanced at the floor, and that's by design. That's what the store wants me to do. So
now, and does it matter whether or not it's a small puddle or a large puddle?
No, it doesn't. If it's enough to cause you to lose your balance, then the puddle is what it is. They're gonna ask you after the fact, what caused you to fall. That's something you're going to determine after you're on the ground. You're going to look around. You're going to notice, oh my gosh, my socks are wet or my shorts are wet. You're going to look over to the side and say, oh gee, look at that puddle with a big shoe streak going through the middle of it. That must have been what I slipped on. You'll want to take note of how big it is. You'll want to glance at it and just make mental note of, oh, that's maybe 6 inches across or a foot across. I've seen a drop of oil, of cooking oil, that was no bigger than a tablespoon, that a woman was wearing heels and she stepped on that and down she went. It does not have to be a huge hazard for you to fall over.
Would you recommend clients taking pictures of what the area looked like?
If they can. I mean, it really depends on how you're feeling when you're on the ground. I mean, if you have a situation where your ankle is bent in such a way that you can tell it's broken, and you don't really want to pull your phone out and snap a photo of it, that's certainly understandable. If you've got a spouse there with you or a friend and they can pull their phone out and take a couple of quick pictures, that always helps. Oftentimes there's video of this, so we're able to sort of reconstruct what happened later. But the most important thing is once you're down there and have a chance to gather yourself, you want to look and see, what is it that caused me to fall? What is it that I put my foot on or in that caused me to go down? Because that's what, when that manager comes to you and says, what happened? You can say, I stepped in that puddle of water, soda, cooking oil, whatever it is, and I fell. And now I'm on the ground and this is what hurts. He's going to write all of that down, and it's going to be your statements later that they're going to use.
The reason why I ask that, because sometimes I see these cases where obviously when somebody slips and falls, then the department will come out and start mopping everything up, and they may start mopping up the area as far as whether it's a puddle or a streak, or like you mentioned, it could be like a line of cooking oil that went 40 feet through the store.
Yeah, and you want to watch for that. If you can get pictures beforehand, that's helpful. Again, we will have video oftentimes of it, but sometimes that video isn't very high quality, and sometimes it doesn't show the exact area where you fell. But you mentioned wet floor signs. That's something that a lot of people will miss at a store. After a fall, it's important to look around and see, did you miss any wet floor signs? Were there any warning signs out there that you should have seen? Because we see a lot of defendants argue, well, I had already put wet floor signs out there. Well, if you look around and have a chance to take photos, you can show that maybe those signs are there, but maybe they're not. Maybe they got put up after the fact, which we see a lot of.
What about as far as an incident report? Is it important to notify the manager to make sure an incident report is drafted at the scene? Yeah,
it's absolutely vital. You've got to notify the manager. Any employee will get the manager. They'll come over and you will draft a report. That does a number of things. First, it alerts them that the incident has happened, and then they begin to document everything at the scene of the fall. Secondly, it will cause them to save the video surveillance. It will give them the responsibility to save the video footage. If they don't save that video footage, then they're breaking the law at that point. And video footage is oftentimes the best evidence you can have in a slip and fall case. I had one not long ago where I had a woman who slipped and fell on a puddle that was right outside a water station where people could go and fill their own water bottles. And they had dozens of spills in front of this water bottle filler because customers didn't know how to use the machine properly and water was frequently on the floor. So they told their employees, anytime you're in that area, take a glance and make sure there's no puddle near the water bottle filler. When we got the video, we were able to play the half hour before this fall, and we were able to show 18 employees of this store walking by this puddle, and not one of them took a glance in that direction. And I can tell you, it's an uncomfortable moment for the manager of a store to be sitting there in deposition under oath, watching the tape with me. And I say, is it that person's job to look at that puddle? Yes, it is. Did they look at that puddle? No, they didn't. And this is employee 17. Is it that person's job to look at that puddle? Yes, it is. Did they look at it? No, they didn't. The store got really serious about settling that case right after that deposition. But if they hadn't told the manager, if they had simply thought, oh, gee, this isn't that bad, maybe I'm not really that hurt, I'm not going to report this, that manager never documents that. We never get that videotape, and then the opportunity to really get what this client lost is gone.
And with these type of cases, what's the difference, or what's the importance of whether or not somebody represents himself, an injured victim represents himself, or hires an attorney? What do you see as far as the difference?
I've almost never seen an individual get money from a commercial entity for a slip and fall on their own. The most you could ever get would maybe be $5,000 or $10,000 for medical payments, and that's really it. Every premises case is defensible, and every premises case is winnable. But winning a premises case requires getting the evidence necessary to convince a stranger that you falling was not your fault. Because ultimately, there's not somebody who pushes you over in a premises case. There's not somebody who runs into you at a stop sign. This is something where you're losing your balance and you're falling. You're the only actor. Now, they have a responsibility for keeping a safe store. And if they fail in that responsibility, you can win your case. But proving they failed and proving that hazard was there for a length of time to where the defendant knew or should have known it was there, that requires effort. And that really requires a lawyer.
And just like in motor vehicle crashes, in these premises cases or slip and falls or trip and falls, is it important not just to hire an attorney, but an attorney that handles these type of personal injury cases?
Yeah, I've got one right now that's in the middle of litigation where the employees of the store told the adjuster at their insurance company their side of the story. And the woman went to an attorney who doesn't do a lot of premises cases, and he really didn't know how to develop the evidence on his side early on. Well, it's a lot easier to get an insurance company to make up their mind at the beginning of a case than it is to get them to change their mind later on in the case. And right now we're fighting an uphill battle because we have to change this commercial entity's insurance company's mind, because they concluded early on they're not responsible for this. Well, if you dig into it and you look at the videotape and you talk to the manager under oath, you get a little bit different story than that adjuster got early on. So it's really important in premises cases. If you feel like you've been hurt, you feel like you may not bounce back, to contact us. Not every lawyer does what we do. Not every lawyer handles these types of premises cases with the experience that we have. It's really important to call us.
So I want to quote Sun Tzu: "Every battle is won before it's fought." To me, that means preparation. Yeah. And really, the preparation starts on day one, doesn't it?
It does. It absolutely does. I mean, the minute that fall happens, that manager is trained to document the scene and document the incident in a way that's beneficial to them. And then the adjuster who gets that claim for their insurance company is trained to contact you. They're trained to get the evidence out of you that makes them look good. Talking to them, they're not going to write down the stuff that helps your case. They're going to write down the stuff that helps their case. And so it's always a good idea. If you're going to go up against experts, it's always a good idea to have an expert in your corner.
And sure, so when you're talking to that manager or that adjuster on the phone, they're prepared essentially for this long, protracted battle.
Sure.
And you're going in, if you're trying to represent yourself, you're unprepared because you don't know where to turn or what to say or where to go next. And so you're already getting started off on the wrong foot or the wrong direction.
Yeah, talking to you is that person's job, right? And they're going to do their job 40, 45 hours a week. You talking to them is what you have to do in order to get back to your life, to get back to your job, to get back to your family. You're always better off early on getting an attorney involved. I want to, as we wrap up here and start running out of time, I want to drop just a bug in your ear about products liability cases. These are rare, but if a product injures you, if a product is at fault for your injury, say a gas canister explodes or a bug fogger causes you some damage, you want to make sure you save that product. The only thing we absolutely need in a products liability case is the product. If you come to us saying that you were hurt when your watch melted or when something caught fire, we need that something. Even if it looks like nothing, we need to have it. So if you think a product has hurt you, please don't throw the product away. If it doesn't belong to you, please ask the person to save it. And if possible, do that in writing, even if it's just a text message or an email. Ask them to save it, and they ought to save it at that point. That's vitally important in a products case. So that is our second episode of Tell Me I Have a Case. You've been listening to Matt Glenn and Dan Grimm. We're at Cook, Barquette, Ponder, and Wolves. We can be found at cbpw-law.com and 573-335-6651. Thanks for listening.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolves today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.